Welcome to the University of Western Sydney School of Law series on Views from the Bench. It is my pleasure to again acknowledge and welcome former Justices of the Family Court, Justice Ian Coleman and David Collier, now both adjunct professors here in the School of Law. And today's session of Views from the Bench, dealing with ethics and etiquette by ADR practitioners and interviewing and negotiation skills in ADR in particular. So, gentlemen, in particular, what do you think is different between an ADR practitioner and a traditional lawyer? Is there a difference?
From an ethical point of view, no.
No, I agree. There should be. I don't think there should be any difference whatsoever. There's no. I don't think. I think whether you're in the heat of battle in a courtroom or the theoretically more constrained atmosphere of ADR, the ethics and the etiquette are the same. Dealing briefly with the ethics, because I think David picked up on this earlier and has said a few things that I think are worth reiterating. I think there's a natural tendency with young lawyers in a profession where there's a shortage of positions for young lawyers wanting them to feel a need, a very real need, financial and social, to make their mark. And I think that can lead them into very dangerous waters where they compromise their ethics out of the misguided belief that in some way is an entitlement of the client or that is conducive to the client's best interests. And that's unfortunate. But as a young lawyer or an old lawyer, you only have one asset in our profession, and that is your good name. It takes a very long time to build up a good name. You can lose it in an instant, and you may never regain that good name, or if you do, it may take you much longer to regain than it took you to gain it in the first place. No client is worth compromising your ethics for. And that's no different in court to in an ADR context. You have the same ethical obligations to your client and to the court of which you are an officer, which in our case is the Supreme Court of New South Wales and the Federal Courts of Australia. When you sign on the roll of those courts, as these gentlemen here would probably just remember, decades ago,
yes,
you accept that you are joining an ancient and honourable profession, which is a great privilege. It's not a right, it's a privilege, and you must respect that, because if you don't, you'll pay a huge price. The etiquette is quite simple. You treat other people with respect, you treat them courteously. That's not terribly hard. The best advocates I've seen, and I doubt whether my colleagues would disagree, have been the most humble. Current Chief Justice, in my limited time in his presence, and the previous Chief Justice, on the same limited basis, you would not come across anybody more humble, nor, I would submit, more able.
Yes.
Judges, the game's changed too, particularly in the Federal Court, the Equity Division. The judges are the product of a different era. They are unfailingly courteous, and they expect courtesy between practitioners. The other thing is, I think your ability to remain courteous and calm and treat your opponent with respect, no matter how disrespectful your opponent is actually a very powerful tactical weapon, because I find in practice that the most aggressive opponents are quite put off their game when their aggression
Is not returned.
is met with respect and courtesy.
Agreed.
They can't handle it.
I would definitely agree with
Yeah,
that.
it is a huge, and it's not lost on judges. If there ever was a time, and I suspect there might have been in the district court when we first started, where it was a knock down,
Everybody
drag
had
about, go your hardest, and there were no penalties for bad behaviour within limits.
Because the judges themselves
were thugs.
behaved badly.
Yeah, but the game's changed, and judges just have no time for dodgy behaviour. And as David would confirm, somebody behaves badly in court before lunch.
Yes.
By the time the judges go back to court after lunch, their staff, judges in other courts in the same building, by the end of that day, they all know.
They've heard about
By the end of the week, half of Sydney knows that got to watch so and so. I'm not saying that he lies to the court or he's but just watch him, and that's a bad thing. Conversely, I have never, even with the worst of judges that we've seen in our time, in earlier times, I stress, I have never seen even the hardest, most difficult judge give counsel who was humble, courteous and well prepared a hard time, without fail. And the reason for that is that the judicial oath overarches everything that the judges do. And it is particularly, I remember a judge saying something to me once, and I in effect said, Your Honour, I always try to be humble. The judge said to me, you have much to be humble about, which was undoubtedly true. But humility, courtesy, respect and thorough preparation. Doesn't matter what court you go to, you'll survive, and you'll survive well.
I echo everything Anne said. Our generation of judges, I think, all determined that they would never behave towards advocates, particularly perhaps younger advocates, the way we were behaved towards by some of the body of judges in those days. The other thing that not concerns me, but I think is a point of awareness with ADR, is that I think that there might be some practitioners who think because they're not actually in a court atmosphere, they can relax just a bit. And that causes me concern, because it is still part of the legal process. They are still bound to act honourably and in the best interest of their client. Balanced against that is the point that Ian raised, which I think is the most important thing that young practitioners have to learn. They have their reputation and nothing else. And it doesn't matter whether it's an arbitration process or whether it's before the High Court. If you fudge and forget for one moment, or worse still, deliberately decide to take a shortcut, it will not go undetected. You will be found out, and the punishment is not a quick cut across the knuckles or 6 of the best. It's spending the next years in a situation where if you say to a judge, Your Honour, I'll do so and so, he says, I'm not satisfied with you. Won't accept an undertaking from you. And your opponents won't accept undertakings from you. Your reputation has to be jealously guarded.
David, can I just interrupt? Can you be a bit more specific about what is the imperative of an undertaking? Many of the viewers today will be still coming to terms with what it means to give an undertaking from a lawyer to the bench and from,
Lawyer to lawyer.
Yeah.
An undertaking is, in my view, a solemn promise. It is either to do something, such as to file a document or pay an amount of money. It can equally be not to do something. For example, someone who has the ability to sign a default judgment gives you an undertaking, they won't sign it. They are promises that you give on your reputation. It will not excuse you for one moment to say, if you don't comply with the undertaking, my client gave me written instructions to do this. Not his undertaking, it's yours. And a breach of an undertaking such as that will undoubtedly put you in bad light before the bench. And I don't mean one judge, I mean the bench. And secondly, might well end you up on a complaint from a fellow practitioner before your governing body, be it the Law Society or the Bar Association. So these things are not lightly given. And if you read some of the disciplinary reports, people come up with the most, what shall I say, limp-wristed excuses. Oh, I didn't use the word undertaking, therefore it isn't one. Well, that's just rubbish. If you say to a fellow practitioner, Ian, I'm in a position to sign default judgment, I won't do it for another 7 days, on your undertaking that you'll file a defence within that time, both of us are given undertakings to the other if Ian confirms that to be so. And either of us breaching that undertaking put ourselves at peril.
Absolutely. Yeah. I think David's point raises two broader points. One is no matter what you do, and we all make mistakes. The young lawyers, I regret to have to tell you, can't expect that as the years advance you don't make them. In my experience, I still make them like I did 40 years ago. But the critical thing is when you make a mistake and you realise you have, come clean. It is amazing, to take David's example with the undertaking. Say an undertaking is given to file something in court. The time is running out to file it, you know you can't. You notify the other side and you make contact in the appropriate way with the judge before whom the undertaking was given. You explain why you can't comply. Your opponent is certain, almost certain, to agree to an extension. Even if they don't, you relist it before the judge to seek an extension of time to comply with the undertaking.
Or a release of the undertaking.
Or be released. You've acted properly. The judge will be on to the other side saying, why shouldn't they? Whereas if you let it go, I had the example this morning where my client just let the time to file an amended pleading expire. We got hit for costs because we, as the judge said, wanted an indulgence. So you come clean and you do it earlier. Coming clean is important, particularly important in ADR, because you misrepresent the truth to a judge in court.
Yes.
It's on the transcript and it's almost straight to the disciplinary tribunal. A lot of practitioners might be tempted, under the guise of confidentiality at mediation, to be a little selective with the truth. And there's a very good chance that they'll get away with it. They won't ultimately get away with it because when the settlement, if there's a settlement, comes to be converted from heads of agreement to a deed of release or court orders, and the critical background facts are checked or confirmed, they'll be revealed. But more to the point, anybody associated, whether it's the mediator or their opponent, will never treat them the same way again. So I think, coming back to where we started, David's point at the beginning, there is no distinction in terms of the ethics and the etiquette or the skills you use. Thorough, well prepared, humble, courteous, respectful, across the whole scenario of the legal landscape, from the first meeting with the client. Now, it's interesting because 40 years ago, the majority of complaints about barristers related to settlements of personal injury cases and family law matters under duress, pressure from the barrister.
As in Crowe, made me plead guilty.
Yep. Today, and I'm sad to say that it relates more to senior counsel than junior counsel, a very substantial body of complaints to the Bar Council every year relate to counsel being rude to clients. So, there it is.
Yeah, do you think
You were talking about reputations, the little black book we all carry. Can I say this also very briefly? Ian talked about admitting a mistake. not only is it proper to do it, at times it can win you an enormous advantage. I can think of a number of judges who I won't name, who you could go before and start by saying, Your Honour, XYZ has happened in this case. I'm terribly sorry, but I don't think it can be fixed. And the particular judges I'm thinking about would, as it were metaphorically, shut everyone else down and say, well, let's have a look at that. And you invariably got very close to what you wanted. Whereas if you tried to bluff it through with those very same judges, you would be carrying the scars for some time.
The same applies to citing authority. It's very tempting only to cite authority that supports your case. But you need to cite the authority which doesn't support you because A, the judge or judges in an appeal context won't think you're trying to pull the wool over their eyes, and B, you have a much better opportunity to address the cases that are not helpful if you raise them and deal with them in your own way than if in the course of submissions where you've tried to pretend those cases don't exist, you're pulled up by the judges and on the run, as it were, have to deal with them. So again,
from the back foot.
It's across the whole spectrum. Everything we do in the law, we should try to do that way, as David says.
Gentlemen, do you think there are any specific skills that universities like ours, who have now a core law unit in ADR, are there any specific skills that you think that we could be focusing on to better prepare our future lawyers going into the profession and going in particularly into the ADR area?
No matter what you're doing, if it involves running a case before the High Court or an arbitration over a modest amount of money, preparation is the beginning. You've got to know your case, and I think, equally important, you've got to know your opponent's case. Your approach, I'm not suggesting you need to be conciliatory, but I'm suggesting you are, if you like, forthright with your opponent in a courteous fashion. You will undoubtedly be courteous to the arbitrator, and you will make a proper and full disclosure of the matters that need be brought to anyone's attention so that the matter can proceed with its best prospects of settlement or at least advancing the matter.
Well, I think, Paul, there is one difference in the skills for negotiation generally to litigation. When you're in court, you have one function only, and that is to get the best outcome you ethically can on the evidence. It's different, and the outcome of the case is to some extent in your hands, but ultimately it's taken out of your hands, the judge decides. In a negotiation, if it's to have any prospect of success, the parties, and I think vicariously to some extent their lawyers, have to take ownership of the dispute. The parties far more than their counsel, but you have to, the expression is skin in the game, which I think is pretty apt. But what I'm trying to get to is when you're running a case, it doesn't matter what you think the claim is worth because there's a trial on. It's going to run to judgment and doesn't matter what you think it's worth. But in the negotiation, I think you've got to, picking up David's point, you've got to have a better understanding of the strengths and weaknesses, but also too, you've got to be constantly aware of proportionality. Time and time again, in my limited experience of it, in mediations, you'll get down to being $1 million apart in a case which is going to cost $600,000 or $700,000 each for two parties if there are two to run. Now, at that point, I think it becomes important that you say to your client, well, look, let's just stand back from this and think about it. Okay, if we spend that and we get our best result, then we're heroes. On the other hand, if we spend that and we end up with their best result, then different scenario. And I think that's the, in terms of skills, Paul, your question, I think that's an essential difference, that you've got extra layers of responsibility when you're negotiating, because the reality is that almost invariably if a mediation fails, the parties will leave knowing there must be an awful feeling to be a party in that position. Go away knowing we have just failed to agree over a sum of money which is less than what we will both spend to find out what the judge thinks. And of course, as we all know, the judge will think a fair thing is somewhere between the two anyway. So I think in a way, with respect to your question, I think that's a very, very important point that it raises, because I think in ADR you've got to have proportionality in mind, and you've got to realise that the outcome is within a range, and those things don't. When you get to trial, those days are over.
Indeed.
It's just
Indeed.
where's the target and how do we get there?
Could I add this though? It seems to me that people who are going to become practitioners in ADR have to have the courage and be prepared to have that very conversation with their client that Ian has just spoken of. I haven't done a lot of mediation, but I've done some. And as was always the case when you were in litigation, trying to settle before you started, there are some practitioners that simply will not say to their client, this is a fair one. This is not a fair one.
Yeah. No, that's
always, look, I don't know, you're giving me instructions, what do you think? And I think the more ADR becomes, what's the word I'm looking for? Not commonplace, because it can never be that, but more generally accepted in practice. People who go into it have to be prepared to say to their client, I think X. Doesn't bind their client, still you act on advice. But where a barrister or solicitor is saying to their client, look, I don't know what it's worth, what do you think is a fair thing? Or, well, if you ask me if I think it's a fair thing, it's still a matter for you, is not, in my view, practicing ADR in an appropriate form.
I think that's right. You've got to say to them, look, you know, it's in the range, and point out the was it Batner and the others.
The Batner and the Watner.
Yeah, they really. I mean, it's interesting that the Batners and the Watners and whatever it is, Malatner or whatever. Anyway, I mean, it's interesting that there's so much the focus on that in the teaching. I think there's every bit as much focus, or should be, on that when you're representing people. And intellectually, it is a very, very helpful series of exercises, I think, to go through in your own mind and take the client through. But and that's the other thing that's implicit in all that we're saying. Be candid with the client.
Yes.
Treat the client not just as someone who's going to write a big check at the end of it, but someone who matters. And the other thing I have to say from a defensive perspective is not every case is one. And clients are far more forgiving after the event if you've taken them into your confidence, which really is their confidence,
Right.
all the way along. You've treated them with respect and courtesy. You've come clean with them. You've said, look, not sure we're on a winner here. We might be, mightn't be. And put them in the picture so they can make informed decisions. And most people, if you treat them properly, are very fair. They don't rewrite history after the event. Conversely, if you treat the clients without appropriate respect and you don't deliver the goods, you can't complain.
If you deliver the goods, you'll love to do them.
It's really treating other people how you'd like to be treated yourself.
And not only your own client, if you can treat the other side, not with abject fawning over them, but with respect, so that both parties can walk away with something of their confidence intact, then not only is the short term, and I'm speaking now perhaps particularly of family law matters, not only is the short term result, but the long term prospect for whatever it is you've either agreed or imposed upon them is going to work, is that much higher. If you just, either as an advocate or as a judge, completely destroy someone, their reputation, everything that they stand for, the first thing they're going to do is, when you've imposed orders, look at a way around.
Oh yeah, I agree.
Well, gentlemen, I think that brings us to the end now. Would there be anything in your concluding remarks that you'd like to make comment of before we close?
No, I think we'd only be going back over material we've hopefully.
All right. Well, look, gentlemen, thank you on behalf of the Dean and my colleagues at the Law School, and certainly on current and future generations of our law students. Thank you for the service that you have given to the law, and David in particular has recently been acknowledged, and Ian, your ongoing commitment as Senior Counsel. We appreciate your commitment and passion in the law. Thank you. Ladies and gentlemen, that now concludes our final session of The View from the Bench. Thank you.
Thank you.